So people often ask, what happens if an officer didn't read me my rights? And I think the general public believes that if an officer, after they arrest you or right before they arrest you, didn't read you your rights, that your case should be thrown out. And that's not what the real remedy is. What you have is what's called a Miranda violation claim, and that is that when law enforcement takes you into custody, they have to read you a Miranda warning before they start asking you questions and interrogating you. So Miranda really requires two things. One, that you're in custody, and I'll talk about what that means in a minute. And then second, that you're being interrogated. That part means that the officers are asking you questions about what they're investigating. So if you are just spontaneously spitting out information and you're not being questioned at all, that's not an interrogation, and then your Miranda protections will not apply. Now, looking at whether you're in custody is an issue that we fight about a lot in court when we're trying to get a statement thrown out of evidence. And at least in Minnesota, there's a 6-factor test. Here's a copy of an order that I just received earlier this week where we had a client's statements thrown out of evidence, and now we'll proceed to trial without his statements being in evidence against him. And that will help his case greatly. It might even result in the case pleading out to a lesser crime or perhaps even being dismissed, which is another benefit of fighting whether or not statements come into evidence, because even if the case isn't thrown out, it makes your defense stronger, and therefore you get better results whether you go to trial or enter into some sort of plea negotiations. So anytime you've made a statement in a case, you want to make sure that you're looking at it to determine whether or not you can have it suppressed or thrown out of evidence because the police violated your constitutional rights, or what's called your Miranda rights by a lot of people. In Minnesota, there's a 6-factor test that's used under State versus View to determine whether or not law enforcement has you what's called in custody. First is whether the police are interviewing you at the police station. The second one is that the suspect is being told that he or she is a prime suspect in the crime. Third, that the police are restraining your freedom of movement, and that doesn't just have to be handcuffs. Fourth, that the suspect is making a significantly incriminating statement, or a statement that's going to hurt them. Fifth, the presence of multiple officers. And sixth, a gun pointing at the suspect. Now, you don't have to have all 6 of those factors in order to be considered in custody. It's a totality of the circumstances test, and some factors can exist while others do not, and some could potentially weigh more than others in this test. But, for example, in this situation, what had happened was I had a client who was accused of terroristic threats and domestic assault after he allegedly told people he'd killed them with the gun he had, and then he started firing the gun. And the alleged victims ran out, left the property, called law enforcement. Dispatch got a hold of law enforcement. Law enforcement responded to the alleged victims, got their side of the story, while other law enforcement was on the way back to the property where my client was. While the law enforcement was traveling to the property where my client was, dispatch aired over the radio all of the information that the alleged victims had told law enforcement, including the type of the threats, the weapon that was allegedly used, and a whole bunch of other facts. By the time law enforcement arrived at my client's property, they had already made up their mind that they had enough evidence based on these allegations to arrest our client for domestic assault and for terroristic threats. So knowing that, they knew that our client was the prime suspect, they knew that they were going to be investigating for this, and multiple officers showed up to the property. One officer blocked in the driveway and blocked the driveway, while other officers approached my client first with their vehicles and then on foot, while they were in full uniform with their badges, their uniforms on, their gun belts on, and all of the other weapons and tools that police have at their disposal. When law enforcement walked up to him, they immediately identified themselves, patted him down to see if he had any weapons, and then they stood on both sides of him and wouldn't let him leave while they began to ask him questions. They told him that he was a suspect in this, and they started asking questions specifically about the gun and those sorts of things. We argued that his statements should not come into evidence because they were what's called inculpatory or potentially harmful in his case, but that law enforcement had him in custody and they interrogated him. Now, the prosecutor argued, well, they never told him that he wasn't free to leave and that they never told him that he was under arrest, and so therefore that this was a consensual encounter or was just merely an investigation at the time, being detained, but he was not what's called in custody, because the prosecutor obviously wanted my client's statements to come in evidence against him. But we argued the presence of multiple officers at the scene, the fact that the exit to the property was blocked by another squad car, the fact that law enforcement already had enough information to arrest him by the time that they arrived and knew that they would be doing so, the fact that indeed he wasn't free to leave and that they were going to question him, and the fact that they did directly question him about these events. And so what law enforcement tried to do, and they're trained to do this, is to ask these sorts of questions without having to read Miranda and get as close as they could to being in custody without being in custody so that Miranda doesn't apply. Then they can ask all the questions, get someone to admit something, and they can use that in evidence against them without having to read the Miranda, because they know if they read Miranda to someone that oftentimes people will then shut their mouths and ask for a lawyer and not make any harmful statements. So this sort of stuff is litigated or fought about in court a lot. But you have to have a lawyer that knows what in custody means, what interrogation means, and knows how to present a challenge to the court and develop enough facts out of the officers and out of the prosecution and with our own client to support our challenge about why a statement shouldn't come in evidence. If a statement is thrown out of evidence, that's a good thing for the case. Sometimes it means that the whole case will be thrown out because there's not enough evidence without the defendant's statement. Other times, though, and in fact probably more often than not, it doesn't mean that the whole case will be thrown out. It just means that the state doesn't have as much evidence going forward, and that might lead to dismissal of some charges or lowering of some charges or better plea negotiations, or it could make a huge difference at trial when a jury doesn't hear, for example, that a defendant admitted some evidence of guilt in their case. My name is criminal defense attorney Ryan Pacyga. If you've got more questions about your Miranda rights or how to keep evidence out in court, you can find me at arrestedminnesota.com or at 612-339-5844.